Hello and welcome to another episode of the Indian Law Show. In this episode, we will straight away discuss 5 legal questions and the answers to those questions. These questions have been selected depending on how useful they are to you. Some of these questions may or may not have occurred in your life but are likely to occur at some point in time in future. So these questions and their answers straight away. And every week I intend to bring up 5 questions from your life and give you solutions to those 5 legal problems. Question number 1. Mr. Kumar has been offered a job in a company, let's call the company X. Now company X wants Mr. Kumar to sign an agreement which binds him to work only for the company and no other company during his employment, which is okay. But the company also wants him to sign an agreement clause which states that after his work with the company, which means after he leaves this company for whatsoever reason, he cannot work for a similar company for a time period of 2 years. So, the question in short, company X wants a future employee, a prospective candidate Kumar, to sign an agreement stating that he will never join a competitor after he quits for a period of 2 years. Is this agreement valid? What are the choices of Mr. Kumar? And here's the answer. Such an agreement is violative of section 27 of the Indian Contract Act. The Indian Contract Act specifies freedom to work, freedom to trade. Now this particular clause falls foul of this provision of a law. Any provision which falls foul of a law is not valid. It is not binding upon the employee to honor such an agreement. Having said that, the Supreme Court's view on this is very, very clear. Supreme Court feels that any such clause cannot operate beyond the terms of employment, beyond the tenure of employment. So if Mr. Kumar quits company X, then it is unreasonable for the company to expect Mr. Kumar not to work in a similar product or a service related company for another 2 years, because that is his freedom to work. So the answer is, such a clause, even if the company signs, even if Mr. Kumar willingly signs it, may and certainly will not be binding on Mr. Kumar to follow. He will be free to work wherever he wants after his tenure with this company. Question number 2 for this week, and very interesting question. Let's call this person Kumar again. Kumar's father had taken a loan from a financier. To repay this loan, Kumar's father had issued post-dated checks. When the time came, the financier deposited the check. The checks bounced due to insufficiency of funds. The financier sent a legal notice to Kumar's father to repay this money. Unfortunately, Kumar's father passes away, and the financier sends another notice, this time to Kumar, asking him to repay this loan since he is now the legal heir and the legal representative of his father. Now, what should Mr. Kumar do? Is Mr. Kumar liable to repay this money which his father had taken and issued a check? The answer is no. Mr. Kumar is not liable to repay this money. Section 118 of the Negotiable Instruments Act clearly mentions that a case under section 138, which is commonly known as a check bouncing case, cannot be brought up against a legal heir or legal representative of somebody who is deceased. So the answer is no. There is a recent Bombay High Court judgment which also mentions categorically that a legal representative cannot be held responsible for checks that were dishonored, and therefore a case cannot be brought up against him. So what can Mr. Kumar do now? Mr. Kumar can now file under section 482 to quash this case in the High Court of relevant jurisdiction. It is section 482 of the Code of Criminal Procedure. If you are not a lawyer, ask your lawyer to prepare to file under section 482 of CRPC, Code of Criminal Procedure, to quash this complaint which has been filed by the financier. The Bombay High Court judgment, which you can rely upon, will now appear below the screen. Thank you. Another interesting question, and this is certainly useful for almost everybody. The question is, one of my friends has downloaded a song from the internet for his research studies. Is it illegal to do so? Well, as long as it is research and educational purpose, it is alright. You can download songs from the internet and you can play. But if you're going to distribute these songs commercially, then you are falling foul of the Copyright Act of India, section 35 particularly, which clearly says that the right to distribute songs, by distribute it means the right to play songs or right to get other people to hear the song, so on and so forth, rests exclusively with the owner of the copyright, which in most cases is the producer of the song. So if it is merely for educational and research purpose, go ahead, download songs from the internet. But if you're intending to play it in a birthday party, then there is a possibility you will fall foul of a law. You need special approvals from the person who holds the copyright to do so. Very good question and very relevant in modern times in India. Hear it, you'll like it. A group of students was involved in a street brawl with another group. In the melee, in the fight, one of the members of the other group had a tooth broken in the brawl. What would be the possible legal action? Well, this can be straight out of anybody's life. Two people or a gang is involved in a fight and somebody loses his tooth. So, what can be the legal consequence of this? Legal consequence for this will be very grave. Section 325 of the Indian Penal Code distinguishes between, well, it doesn't distinguish, it defines grievous hurt, grave hurt. There is something called simple hurt and there is something called grievous hurt. Now, in this kind of hurt where bone gets fractured or where a tooth is damaged, imprisonment can go up to 7 years. So, unfortunately for the person who broke somebody's tooth, who broke this person's tooth, if convicted, he'll go to jail for 7 years' time. The difference between simple injury and grievous injury is one that can be distinguishable using little common sense. If it's just a slap and some marks have appeared on the cheek, it's alright. If it's just a scratch here and there, it's okay. But if a bone is fractured, in layman's language, if hospitalization is required for serious treatment, then the person who inflicted this injury will go to jail for 7 years. And the last question for this week, and I'm choosing this question because the answer may probably benefit a lot of people out there. Mr. X currently resides in the United States. His wife leaves him and comes to India and says she does not want to go back. Can Mr. X file for restitution of conjugal rights in India by giving a power of attorney to his mother, the girl's mother-in-law? And here's the answer. In this answer, I'm going to first tell you what is restitution of conjugal rights. Restitution of conjugal rights is a legal mechanism where one spouse approaches the court of law and requires that his or her spouse be made to live with her or him. In other words, if one of the life partners is away for whatever reason, maybe she wanted to be away or maybe she was taken away by her parents, whatever reason, there is one approach that you have for legal remedy, and that is called restitution of conjugal rights. It sounds very Greek and Latin and very bombastic. It's very simple. Conjugal rights, rights of a couple to be together or rights to remain together. Restitution, making it happen once again, or restoring. So, restitution of conjugal rights I just explained to you. Now, in this particular instance, he is in United States, she deserted him or she left him and whatever, and we are not clear what exactly happened. She is now in India. Can he use this right which is granted to him in Indian courts while sitting in United States and giving the power of attorney to his mother? It's a very strange thing that he's asking his mother to bring his wife back. It may not work out at all. But the answer is yes. Courts have been known in India to recognize such a right. Latest trend is to allow such a person to come in and represent the other person who may or may not be available. In some instances, the court may require him to be present personally. If that happens, he'll have to travel all the way back to India and be present personally. But the answer is yes, a right to restitution of conjugal rights can be executed through a power of attorney if that person's presence is very difficult. This is the 6th episode of the Indian Law Show. We are trying very hard to bring useful information to you free of cost. I will try and experiment with this format. I'll try and make sure that this program becomes more interesting and draws more viewers. I'll be very happy if you send me your feedback, send me your responses, send me your queries. If you send me a query, I'll be very pleased to bring it up, find a solution for you and answer it free of cost. My email is visible now at the screen below and I look forward to hearing from you, and I promise you that I'll return with better format, more interesting legal news and legal information that will save you money and that will make you more empowered. Thank you for watching me. Thank you.